As it says, I was threatened with a defamation lawsuit, and all I got was a T-shirt. That's a lie. I didn't even get a T-shirt. It was the most expensive not a T-shirt I've ever had. Big disclaimer. I want to be extremely clear about this. No confusion. I am not a lawyer. This is not legal advice. Do not take this as legal advice. Everyone got that? Anyone still think I might be a lawyer? I've got more style, but names have been removed to protect the innocent, as you'd expect, and of course the guilty. And yes, I have stickers. You can have them after the talk. So, how it went. Once upon a time, James here was sitting on the internet, browsing away, as you do. For legal reasons, I cannot name the person who was browsing the internet, as you do. They were fairly level-headed and conscientious, and they care about people making aggravated claims online. They may have ranted about it more than once or twice. And they browsed a particular social network. And then someone was wrong on the internet. Quite a familiar situation, I'm guessing. As we all know, most people are wrong on the internet most of the time, except me. In this case, it was an annoying sort of wrong. It was claims about something they had done, which were aggrandised. They were being evidently criticised, so every criticism was carefully evidenced. They were lying in a way that could cause harm, which tends to upset our unnamed protagonist. So, our protagonist posts about this and says a few things and posts on an unnamed professional social network, makes a few comments, forgets about the whole thing. This is not an uncommon occurrence. It doesn't stick in your memory. Went on their way, not thinking about the situation. Until... bang! Suddenly, a few months later, our hero has completely forgotten about this incident, utterly out of their mind, and a message arrives from a legal firm. Looking very odd. Looks like spam. Just like your standard phishing attack. Attachment, no real names mentioned, very vague details. Checks up on the legal firm, goes back to them and says, I think you may have a compromised email account here. I can just walk you through what's happened and maybe help out. Gets a reply from the legal firm saying, no, it's genuine. You can read the attachment. We will send one by the post if necessary. So, opened the attachment in a sandbox, just in case. Yeah, it's definitely a letter. Found the phone number of the legal firm again. Found the phone number of the appropriate lawyer there. Called them. What's this about? Right, well, this is a pre-action letter. As in, if you do not take the actions we've said, we are going to sue you for defamation. The things that our hero would have to do would be, I've got a list here so I don't forget, remove their original post. Okay. Publish a prominent apology recanting every claim made in the original post. Promise to never make any defamatory statements ever again. I mean, that's a problem for our hero. Make a statement in open court apologising for all the alleged wrongdoing. Now, that involves going into open court, making an admission of guilt of defamation, and a formal apology that will be on court records forever. Pay substantial damages. They didn't name the damages or give a number, but substantial was described. And pay all legal costs. If they fail to do those things, there will be legal proceedings for libel. Now, getting personal, if you've never received a threat like this, it is difficult to understand the impact it can have. In our hero's case, it felt like being punched in the gut. It was sickening. There was nausea, there was panic, cold sweats, genuinely visceral reaction. This felt like a physical attack. It is a panic reaction. That was the first reaction. The second one was pure unadulterated rage. Incidentally, SLAP there is not misspelled. SLAP stands for strategic litigation or strategic lawsuit against public participation. We'll go into a bit more of that. SLAPS. There's a coalition, a group called CASE, Coalition Against SLAPS in Europe. They work to prevent these from being used. They are mainly used by politicians to try and silence journalists, officially speaking. Strangely, politicians seem to take little proactive action to minimise their usage. I cannot imagine why that might be. The high-profile cases are the ones against journalists, activists and similar. There are civil cases. There are a lot of civil cases that never make headlines. Now, in the statistics, and again, I'm sorry, I'm going to read, CASE says there are, or were, 820 cases in 2023. Those are the ones that are high enough profile to hit that bar. I know that of the particular case that targeted our hero, there were at least 6 other people targeted by that same one. These are used a lot, and they don't get spoken about. Our own government described them as fundamentally undermining speech, free speech and the rule of law. But MPs may or may not use them, as has been publicly documented. So it's very little help. CASE try to act against them, but they don't give support to people targeted by them. If you're a journalist, you will have a media company backing you. They have very expensive lawyers. Good for them. If you're not, you probably don't have very expensive lawyers. Who here has a full, expensive legal firm on retainer at all times? I was actually expecting some of you to have that. Okay. A slap, by the way, is a sign that you are annoying the right type of person. So, this was, of course, when our hero, being sensible at all times, leaps into action, contacts his legal firm, and immediately responds to and deals with the case. Not quite. It's not going to be that smooth and simple. As I said, the first reaction was panic, the second was rage. Then it was a confusing mess of the two for several days. Completely unbalanced, completely thrown off, unable to concentrate on things. This is a serious legal threat. Fortunately, our hero has some legal people who are counted as friends and may owe favours for previous talks or be willing to talk because he bought them a pint once. So, reaches out to these people who all say, yeah, it's a nonsense case, but you have to take it seriously. Great. Well, that's really useful. How much would it be for you to take it seriously for me? Well, to bring in my insurance because of my particular position, to bring in the firm, that would be £3,000 for the initial consultation and then maybe a few more to write the letter. Very nice people, but they do have to charge to bring in their insurance, to bring in their professional indemnity, remember those 2 words, and to actually engage the full legal framework they need to. Another note, the willingness of both some legal firms and some individuals to put people through this because their feelings are hurt by honest criticism should tell you a lot about those people. Also remember, flippant humour is a defence against trauma and negative experiences. So, you will know innocent until proven guilty. Does that always apply? Anyone tell me one of the cases where it doesn't apply? There's a clue in the whole talk here. Not necessarily civil, sorry?
Innocent guilty not proven in Scotland.
I don't care about Scotland. That's their problem.
I'm guessing it's defamation.
It's defamation. In a defamation case, it's interesting. Arguably, innocent until proven guilty applies. Innocent of the aggrieved party. They are assumed to be telling the truth about their damages and about the fact that you, the defendant, are lying about them. You must prove that you have a defence. Otherwise, you are assumed to be guilty and must pay damages and do everything else. Again, I am not a lawyer. This is not legal advice. This is potentially useful information that you can then talk about with a lawyer should it become relevant. So, truth, justice, and the American way. The 4 defences against defamation. Defence number 1, truth. This is true. I can prove it is true. There is no doubt. I can absolutely prove this. Look, here are the receipts. Here's the evidence. Great. Absolute defence. Case ends there. Once it's got to court. Secondly, reasonable opinion or honest opinion. I believed it was true because every shred of evidence I had at the time showed me it was, and any other reasonable person would believe the same. Again, it's a defence once you get to court. It was a publication in the public interest. Guess which one journalists tend to use? Guess which one isn't really available if it's not a major publication with a major public audience? And finally, I'm a politician. I was in the House of Commons. I'm allowed to say what I want and no one can do anything about it. Parliamentary privilege. Of course, we're not allowed to call them lies. Free speech for all, yeah? There is also qualified privilege. Now that's in particular cases, it's really wibbly, talk to a lawyer. So, this was advice our hero received from a lawyer. If you go to court, no matter how strong your case, no matter how much you can prove, no matter how much work you've put in, no matter how committed you are, you can always lose. And if you lose, it's going to hurt. And more importantly, getting it to court takes time and money, and a lot of both. And it's also all on the person making the claim of defamation. They can choose to abandon it at any moment, meaning all of your effort is wasted. Now, fortunately, our hero was lucky enough to have the previously mentioned contacts in various legal firms who were friendly and helpful and said, yes, I will charge this much money for it if you want to do it. Even more fortunately, before going on the immediate knee-jerk or the second knee-jerk rage reaction and posting about it and splashing it everywhere, he reached out to them and spoke to them. And they said, first of all, do not antagonise these people until you're ready to. Which is very good advice. So if you're in this situation, don't knee-jerk start shouting about it. It is tempting, particularly if you know that you're in the right. But if you do that, it's not going to help your case. So, what do you do? Well, remember these letters come from law firms, bottom-feeding firms, the type of ones who pursue frivolous copyright infringement claims and defamation claims. You will find law firms that specialise in these. I am sure some of them are good. I'm sure some are. And that's about it. That's where you get to with the legal advice that you can get for a pint of beer. So it's always preferable not to go to court. It's always preferable not to publish too much about it, certainly with specifics that could be traced back to the case later on. So what do you do? Well, you could go private. You could go and hire a lawyer. That is a representation of the money involved there. If you work for a large company with a large legal defence fund, that may be an option. It's probably not the option they'll use, but it may be one. If you're a billionaire, definitely an option. But they are expensive, and frankly, if you're wealthy enough to go and engage a private law firm to defend you without blinking and without selling your house, you're probably not going to be in this position, because every time you go on the internet, 3 lawyers are standing behind you saying, don't post that. So for everyone else, if you've got to choose between paying rent or being sued, what do you do? Insurance. And there's 2 options. We have personal insurance, your home insurance, your life insurance, and we have professional insurance. So what capacity were you acting in when you made the allegedly defamatory claim? Was it a professional comment or was it a personal comment? Insurance companies are your friends. I'm sorry to say it, they really are. And whichever way you go, whether you try to claim on your personal insurance or your professional insurance, they are going to ask you to prove that you were acting in that capacity. Keep receipts, keep evidence. If, for example, it was on an unnamed social media network for professionals, be able to prove that your activity on that network is directly tied to your insured business. Because if you can't, you're acting in a personal capacity. And most of us do not have the appropriate personal insurance. We'll get to that. But if you're acting in a professional professional capacity, yes, better. If you work for a company, any company, if you work for someone else, can pretty much guarantee they will have professional indemnity insurance. If you are acting in your capacity as a professional of that company, you will be covered. If you are independent or own your own company, like our hero, get professional indemnity insurance. Have it. Make sure it covers you. Defamation is included by default in most policies, but get the insurance. Doesn't cost much, and you'll see why you know why it's worthwhile. £3,000 just to talk for a bit, and then more for a letter. I'm just going to repeat that. Get professional indemnity insurance. Yes? You may get bored of hearing that. If it's personal, your personal liability cover on your home insurance does not cover defamation. You want personal injury. That will cover you for defending against defamation or prosecuting it. And that is not included by default. So check your policy if you're going to go around slandering people. If anyone wants to screenshot that, just so you remember it, get professional indemnity insurance. Particularly if you're going to go around poking bears. So, as long as you've got the insurance, it is actually quite simple. First thing you do, notify your insurer of a claim. Tell them, someone's threatening to sue me, I've got no idea what's going on, please help. They will then immediately come back with and say, well, were you acting in a capacity that's covered by our insurance? Now, to be absolutely clear, this is not the person processing your claim trying to refute it. This is something they have to do. So if you're going to your professional indemnity, make sure you can say, yes, I was posting it on this unnamed social network for professional activities in my professional capacity as a corporate truth teller and someone who, for my own professional reputation, must call out charlatans and con men online, or possibly con women. I don't want to give away identifying information. That might come back to haunt me. So notify your insurer of a claim. Know how to do that. It's usually just an email. Step 2, follow the system. Once your insurer has accepted the claim, which might take a few days, they will very quickly, genuinely very quickly, within about 24 hours in this case, assemble a crack legal team who are experienced in dealing with exactly this on your behalf and tell you what your excess is, just in case you've forgotten. Talk to the legal team. The legal team are on your side. Literally, they're paid to be on your side. And they don't want to go to court because they could always lose. They want to settle it out of court. They want to deal with it quietly. Now, there's a whole process with defamation where you get the letter, you can go to mediation, you can try and settle outside of court. Eventually, you get to court. By then, the house is sold, the dog has been sold, you're rapidly running out of funds and everything's gone horribly wrong. So don't do that. Talk to the legal team. Tell them, this is why I think it's irrelevant. What can we do? Step 3. They write a letter. Now that should be a slightly smaller bag of money. They write a letter. They send the letter. They say, you probably won't hear back. Here's the bill. If it's professional indemnity, by the way, you will be paying not only your excess, but the entirety of the VAT for the bill. Which, if you're VAT registered, is reclaimable. There are advantages to VAT registration despite the paperwork headache. And honestly, that's it. This is genuinely where this story ends. The letter is sent and you never hear anything else. If I come backwards. No. So who did it? Defamation law has a statute of limitations of 1 year. Poking people before that has expired can have consequences. 1 year. Watch this space. Thank you, I've been absolutely great. Buy my book, it's really good.
Thank you, James.
And remember, get professional indemnity insurance.